Yeah, good afternoon, everybody. It's Alex Rook here from Irwin Mitchell, and I'm here with Steve Broach, barrister from Monkton Chambers.
Afternoon, everyone.
And we are doing this webinar on using the law to challenge the cuts. Hopefully you can all see the slides. There's a nice welcome to you all from Contact, who've organised this webinar today. As it says on the slide, if there's a technical hitch, which of course we're not expecting there to be, but if there is, please do bear with us. We've got some good technical online support. And as it says on the slide, all being well, you should be able to see this introduction slide. The plan for today is that you are now going to hear from Steve Broach, who's going to spend about 15 minutes talking about the law in this area, and he'll then pass back to me, and I'm going to do the practicalities, or at least try and touch upon some of the practicalities about what you should know when considering a legal challenge. We had hoped to have a couple of the parents here with us today from the Nascot Lawn case that some of you may have heard about. Sadly, they've been defeated by the snow, but they've both confirmed that they're happy to be contacted directly afterwards if people have particular questions they wanted to ask families who've been through this scenario. And then, so after you've heard from me, that should then leave about half an hour as a Q&A session, and we've deliberately left quite a big chunk of time there so that people have an opportunity to ask any questions that arise. Feel free to email the questions through as we're going, and they're all going to be collated and sent through to us, and we can then respond to those in the second half of the session. Steve, over to you.
Thanks very much, Alex, and good afternoon, everyone. Very pleased to join you all today. As Alex says, I'm going to talk primarily about some of the key legal principles that are relevant to cuts challenges, both in terms of conversations, discussions that might be happening locally between individuals, groups and public bodies, but also the kinds of principles that are used in the cuts cases, those ones that do go to court via judicial review. And the timing for today's webinar is perfect, really, because as of this week, all the local authorities in England have now set their budgets for the 2018-19 financial year. And that means we now know what the financial envelope will be for services for disabled children, young people and families. Although, of course, the precise configuration of any cuts is still likely to be worked out. That detail will be worked out during the next few months. So we have the budgets set, and budgets are important, but they are, of course, just estimates of financial expenditure, like a household budget or a company's budget will be. And there is some limited flexibility in them. Local authorities will still have some free, unrestricted reserves that they can draw upon. But we know from some of the case law that once a budget is set, it's very difficult to argue that any more money should be spent. What you're left arguing about really is the way in which the available funds should be divided. And a case called Dom against Hammersmith and Fulham in relation to adult social care charging shows that even where there's been non-compliance with, in that case, the public sector equality duty, which I'll come back to, if the budget's been set, there's not very much the court is likely to do about that. So the time really is now, and that's why it's great that we're having this webinar today. Of course, before we get on to any of the specific grounds of challenge, we all recognise the importance of co-production and working with local authorities and public bodies where at all possible, and the key work that the parent forums who are supported by Contact do in this regard. In my view, there's an important point about timing here, because that work is really particularly relevant during the extensive process of consultation and discussion by which budgets are set. But there does come a point, and that point is now, where those budgets have been set. And really, there's very little that can be done, in my view and in my experience, to change those decisions other than through legal challenge. So it may be that we're now at the time when individuals and campaigners need to come forward and take on any cuts which in their view may be unlawful or may particularly disadvantage disabled children, and young people. So if we move on then to what the grounds of those challenges might be, I've identified in the very short time that we've got this afternoon, three types of legal challenge that might be used in relation to cuts cases. And the background information on all of these is a blog post that I wrote a couple of years ago now, where I identified some key legal questions that can be asked to challenging local cuts. And I went back to that blog, and pretty much those all still hold good in terms of what the key duties and principles are. And we'll look at an example of each: a specific duty, a sufficiency duty, and a regard duty. And I'll explain what those mean in a moment. So if we think about the sort of specific duties we can rely upon. Now, specific duties are those which are owed to individual children or young people, and which in some cases are absolute and are not in any way dependent on the local authority or the CCG's resources. And an example of that is in section 42 of the Children and Families Act. It'll be well known to many of you that the local authority must secure the specified special educational provision in an EHC plan for a child or young person, and the CCG must arrange the specified health provision for a child or young person. Now, those are absolute duties. That, in my view, is completely clear. In the Court of Appeal, Lord Justice Sedley said in the North Tyneside case that the previous duty under the Education Act, which was in very similar terms, was not a best endeavours duty. It was not for the local authority to try their best to secure the provision. They simply had to secure it, come what may. And the same, in my view, must apply to the duty on the CCG, which is very important and unusual to have a specific duty in the health context. The NHS normally operates on quite broad general duties, so this one is very valuable. So that seems to me, by extension, to mean that it must be unlawful, or at least that it's very likely to be unlawful, to cut funding that's been allocated to support the implementation of education, health and care plans. Because if, to take a round figure, £1 million was necessary to ensure that provision was secured in 2017-18, how can it only cost £900,000 to secure that provision in 2018-19? At the very least, the local authority is going to need a very good reason to explain that decision. And there are many other specific duties, of course, lots of which are covered in the Legal Action Group book, Disabled Children, a Legal Handbook that I co-author, and in social care we have the Chronically Sick and Disabled Persons Act duty, which again, once you get through the thresholds, is not resource dependent. The necessary provision must be arranged. So that's specific duties, and of course any of the things I'm saying, please do ask questions about and we'll cover in more detail. Then move on to sufficiency duties, and this I think is a particularly promising area for cuts challenges, because Parliament has been very keen in the past, say, 10 years in imposing duties on local authorities in particular to have a sufficient supply of certain things that are deemed to be valuable. And most notably in our area, that includes short breaks. And so that we have the Breaks for Carers of Disabled Children Regulations 2011, which include at Regulation 4 a sufficiency duty in relation to short breaks for children, of course, those being those up to 18. And I've put the key wording from Regulation 4 on the slide. Local authorities must provide, so far as reasonably practicable, a range of services which is sufficient to assist carers to do two things: continue to provide care, so that's crisis breaks effectively, or importantly, to do so more effectively. And that term effectiveness, which is slightly odd, is then defined in relation to people's ability to study, to perform other household tasks, to look after other children, and so on. The only thing that it doesn't apply to is to work, because the service that supports working is childcare. That's the legal difference between short breaks and childcare. And so in my view, and this was not disputed in the case that happened against West Berkshire in 2016 in relation to their cuts to short breaks. In my view, what Regulation 4 requires local authorities to do is to understand the demand for short breaks, to have assessed the demand, to have understood what's available, the supply of short breaks, and to at least consider what more they can do so far as reasonably practicable to make sure the supply matches demand. And it is that reasonably practicable caveat which stops this from being a duty to achieve a particular result. that the local authority can always say, well, we'd love to provide more, but it's not reasonably practicable. But if that is their position, and if they recognise that there's a gap between supply and demand, then they will at least need to explain why it's not reasonably practicable to do more by reference to other competing demands, financial position, and so on. It won't be possible, or it won't be lawful for a local authority to simply say we can't do more without explaining why not, because so far as reasonably practicable is still a strong duty on the local authority. And there are a number of other sufficiency duties which I cover in the blog post. For example, the Child Care Act duty in relation to childcare. There's another duty in the Child Care Act in relation to children's centres, and so on. And then we have the third kind of duties, to wrap up my introduction, which apply in relation to regard. So these are expressly duties where the job of the local authority is to have regard to something which Parliament has said they need to consider. And of course, many of these apply to CCGs as well. And Section 11 of the Children Act 2004 is one of those duties that apply to both local authorities and CCGs and a number of other groups. And what Section 11 mandates is that public bodies have regard to the need to safeguard and promote the welfare of children in everything they do. So in all actions, in all decisions, in all policy setting, in all cuts, the need to safeguard and promote the welfare of children must be considered by local authorities. There was an important Section 11 case in our area at the end of last year involving Hillingdon and a disabled child and his single mother, J and L. And that was a case where, in short, the family had fallen between the gaps between children's services and housing. And what the judge said in that case was that the duty under Section 11 must be exercised so as to ensure that the welfare of the child is actively promoted. And that's a quote from what Lady Hale said in a Supreme Court case, HC, Lady Hale being, of course, the President of the Supreme Court now. So that really does stress how far Section 11 goes, because that phrase, actively promoted, suggests to me at least that it's going to be very, very difficult for a local authority to cut services for children, because a direct cut to those services will do precisely the opposite of what Section 11 requires. It will not actively promote their welfare, it will actively undermine it. So we wait with interest to see what the courts make of that obligation in a case that's about policies and cuts rather than, as in JNL, a case that's about individual children. It's very clear, of course, that Section 11 does apply both when policies are set and when decisions are taken in individual cases. The other most notable due regard duty, as it's phrased in that instance, is Section 149 of the Equality Act 2010, which is the public sector equality duty. And I doubt there's been a cuts case in the last 10 years that hasn't referred to the PSED or its predecessors. And what the PSED says is that local authorities and other bodies have to have due regard to a series of needs, including the need to advance equality of opportunity for, in our case, disabled people. That phrase, advance equality of opportunity, has some similarities to safeguard and promote children's welfare. And again, it will be difficult for a local authority to justify cuts that are directly contrary to disabled people's equality of opportunity. And at the very least, they will need to show significant consideration of that need and what can be done by way of mitigation or other steps to promote that without necessarily stopping the cut. So those are the key duties. And just to touch on a point that I know has concerned a number of people, which is, well, what's the point of these sorts of challenges, and what do you get through judicial review? And Alex is, of course, about to talk about the process much more. But I just wanted to flag at this stage some really excellent research by the Public Law Project titled The Value and Effects of Judicial Review. And I've put the link on the slides. And what the PLP found was that claimants for judicial review generally gained a wide range of tangible benefits, the most common of which were conferment or retention of a service by a public body. So it is possible, of course, that people win a judicial review and then the public body goes away and takes the same decision again, but does it properly this time. But that isn't our general experience. In many cases, judicial review is an effective tool to challenge cuts. And with that rallying call in mind, I'll now pass over to Alex for the second half of the talk.
Thank you, Steve. There's obviously on the slides Steve's direct contact details. So I'm now going to spend about 15 minutes or so, as it says on that slide, talking about what you need to know when considering a legal challenge. Hopefully this is all going to be practical information. As we've already stressed, I hope, please do fire through any questions you have about the legal duties that Steve has just set out, or about anything which I'm about to set out now as well. So there's a summary of what I'm going to cover, those 4 points: who can bring a challenge, how to fund it, how we go about challenging decisions by public authorities, practically how does that happen. I want to briefly touch upon consultation. It's a very large topic in itself. And then finally, there are some specific details about legal aid funding for individuals who are wondering whether they themselves or their children would qualify for legal aid. Again, I'm going to rattle through that last point relatively quickly, because there's a very helpful online tool that you can use, and there's a link to that on my slide when I come to it. So the background to this, I think it's worth flagging, is that, as it says on the slide, we all understand times are tough. There are a lot of pressures on local authorities and NHS funds. It's important to recognise that, but at the same time, as individuals, the law must be complied with, and local authorities and the NHS, whether that's a CCG, clinical commissioning group, or whichever body it is, must comply with their legal obligations, despite the difficult financial circumstances that they find themselves in. And of course, if local authorities or the NHS find themselves in those difficult positions, then those are matters that they should be picking up themselves, rather than impacting upon disabled children, disabled adults, whoever it might be. And as I say on that slide there, the courts have repeatedly emphasised that in this difficult financial climate, it's all the more important, not less important, that decisions which are going to have such significance about cutting services are properly thought through. And so the public body properly understands the impact of the decision it makes when it sets that budget. And that's a really important part of our democracy, is that it's not for the courts to tell local authorities or the NHS or whatever it may be how to spend their money, but it is for the courts to make sure they do that in a lawful way. And what that means is, have they properly understood the impact of the decision? And very often what we're arguing on behalf of families is that if the public body did properly understand the impact of its decision, it wouldn't in fact go ahead and take it. And that takes it back to the point Steve was just making, and that I will also come to again shortly, about what are the consequences of these decisions. So very briefly, who is the claimant? As it says, there are broadly speaking, three ways in which someone can advocate and support bringing a challenge. The first is it's brought by an individual claimant, or that may be via litigation friend if that claimant is a child, or if they're an adult who lacks the capacity to litigate themselves. And the litigation friend is normally, although it doesn't have to be, but normally a parent or a sibling who's acting on their behalf. Claims can be brought on behalf of an organisation. That can be a charity or a lobby group, whatever that may be, although that's much less common. And then thirdly, organisations or charities can intervene in cases where they have a wider interest. And so, for example, in the case of Nascot Lawn, Contact filed a witness statement within our case, albeit that the case was brought on behalf of 3 families, explaining to the court the wider impact of short breaks and the challenges that cuts to services bring. It's fair to say, however, that the vast majority of cases are brought by an individual claimant, point 1 there on that slide, and that's what I'm now going to focus on hereafter. So legal aid is available for these types of cases. There obviously has been quite a lot of media attention to the cuts that have been brought to legal aid, but absolutely no question that legal aid is available in this area to challenge the lawfulness of decisions. But legal aid has a merits test, which is that point I've just raised, but also a means test, i.e. does the person financially qualify for legal aid? And that is a strict test which is set by the legal aid agency, and that's the point 4 of those slides that I just referred to, where I'm going to briefly touch upon what that financial test is. For reasons which I have to say personally I don't think make a great deal of sense, but nevertheless it's the way that the system works. If you have to go to court on behalf of a child, the means of that child are assessed to establish whether the person qualifies for legal aid. And so most children will automatically qualify for legal aid unless there's a trust fund or something of that nature. But the initial bit of work that we as lawyers have to do is assessed on the whole family's means. And so there can sometimes be a bit of a difficulty there, where the initial bit of work can be more difficult to fund, and that's the kind of investigatory bit. But if you are going to go to court, legal aid is then available. And legal aid is really important for 2 reasons. One, because of course most families don't have the means to bring litigation, but it also, as it says on the slide, gives protection against an adverse costs order. And what that means is that the normal rule in these proceedings is that the loser must pay the winner's costs. And that's there to provide an incentive to all parties to try and settle the case. What that means, of course, is that there's kind of good news in that, insofar as it means if someone was to bring a case and win, they would get at least the majority of their costs paid by the losing party. But it also opens up a risk that if you bring a case and lose, not only do you have to pay your own lawyer's fees, but you have to pay the other side's fees as well. But none of that applies for legal aid. And so what it means is that if you were to bring a case on legal aid, the legal aid agency would pay your own lawyer's fees, and the legal aid certificate provides a cost protection against having to pay the costs of the defendant, in this case the local authority or the NHS body. In a nutshell, it means you are not going to have to pay anything. Increasingly, you'll find crowdfunding has a role to play here, particularly in cases, as I said before, where the family's means mean that they can't get the initial investigatory bit of work done. Conditional fee agreements are possible, but again, in cuts cases, in my experience, the vast majority are still funded by legal aid. How to go about doing this? Well, I mean, yes, we're lawyers, but it's right to say that if matters can be settled amicably through discussion or lobbying, work by national charities, local groups assisting, writing to your MP, all of those things are really, really valuable and shouldn't be discarded. And if an outcome can be achieved that way, then that probably would be ideal. I don't think anybody wants to choose to immediately go to court. The difficulty with that, however, as is put in bold and underlined in the middle of that slide, is that one can't delay. And the reason for that is judicial review proceedings, which is what we're talking about here, challenging decisions by a public body, must be brought promptly and in any event within 3 months. And so that 3 months is a long stop. It means if a decision, so let's say a local authority decides to close a respite centre, the date of the decision would be the decision that council make that decision, and a challenge must be brought within 3 months or you're going to be out of time. Actually, the situation is even worse than that, I'm afraid, because like I said, it says promptly and in any event within 3 months. And the court will look very carefully about how quickly somebody has acted. And indeed, if in my made-up scenario, a local authority is closing a respite centre, if the respite centre is closed within a month and a half, I think it's very unlikely that the court is going to order that centre to be reopened, to re-employ staff. It may be that children have moved to different placements. And so the court will say, well, the administrative difficulty of reopening that centre outweighs the consequence, and so the court may say that you're too late even if you do that within that 3 month period. And in Cutts cases, which is what we're primarily focusing on today, that's all the more relevant. And so often we would advise clients that cases would need to be issued within a couple of weeks in order to try and get the court to look at challenging these decisions. And if I'm to use the Nascot Lawn case as an example, that case was issued very, very quickly, and the court recognised the urgency of the matter, and the court listed the matter very, very quickly so that it could be addressed before there was any risk that the service was going to be closed. The best example I can give of that, in fact, was a case which on consultation, which I'll come to later, which is a case of called Mosley, which was actually about a consultation about council tax. And in that case, we in fact notified the local authority before they'd even taken the decision that we were likely to challenge it if they did take the decision. And I believe the case was issued within a number of days after the decision was taken, because it was a multi-million-pound decision. And we felt, and I think the court agreed, that if we weren't going to act at that kind of timescale, it would be too late. And so promptly there would probably be a few weeks, not a few months. So moving on, judicial review is the procedure by which the High Court will review the lawfulness of the decisions made by a public body. It's important to identify who is making the decision, what is it, when, and I think I've already dealt with there the highlighted points about acting promptly. Our job as lawyers is to find that final decision and make sure that there is no further appeal remedy that can be used, judicial review being the remedy of last resort. And broadly what we're going to be arguing is that the public body is acting outside its powers, it's acted irrationally or perversely, or there's some kind of procedural impropriety. It hasn't consulted properly, hasn't acted in accordance with the Equality Act, etc. The key point there being, we aren't saying we don't like this decision. We aren't saying we think that the public body should do something different, because that's not the role of the court. The role of the court is to say you can't do this, or you've acted so unreasonably that it's going to meet that kind of irrationality threshold. Steve's already touched on this already. Victory will lead to the decision being overturned or quashed. And often negotiation during the litigation will get the result that you want. Although what that does mean is that it's as though the decision never happened, and it then goes back to the public body in most circumstances for them to re-look at the decision. And so that does mean that the public body could, in theory, lawfully look at it again and retake the decision we don't like, but this time do it in a way which the courts will say is lawful. That said, our experience is that often that is not the case. Again, that might be something for questions at a later point. I'm conscious of time and the need to move on. I have just briefly touched upon here about consultation. Again, this might be a point that people want to have questions about, because consultation is an issue that we are regularly contacted about. First of all, there's a question about when does a public body have to consult, and I haven't really touched upon that a great deal in these slides, because in most circumstances, although not all, but in most circumstances where a public body is consulting, they will accept that there is an obligation on them to consult. What that means, though, is that a public body saying we are consulting does not mean it is a lawful consultation, and I've set out there the kind of headline points of what a lawful consultation should look like, and that means it must occur at a stage when the proposal is at a formative stage. That means that the public body hasn't decided what it's going to do and it's just going to then go through a kind of tick box exercise. Really importantly, and this is often, again, in my experience, where cases about whether the consultation was lawful or not will focus, is have the consultees, the members of the public in most circumstances, been given enough information in order that they can properly respond to that consultation. And that was the ground upon which we won in that Mosley case, which I've referenced above. So do you properly understand what is the information, what are the alternatives, why are they doing that, and are you then able to properly engage in this consultation exercise? Thirdly, have you been given enough time to respond to it? And fourthly, have the public body then properly considered the responses they get to that consultation before they then decide, are they going to go ahead and make this cut. And so, you know, a particularly stark example that I was involved in a few years ago, where the public body immediately gave in, where they embarked upon a consultation exercise and then taken the decision to make the cut 3 days before the consultation had even closed. That, I would say, was plainly unlawful, and indeed the public body, as I said, accepted that it acted unlawfully just in response to our initial letter before claim. I've set out there on that slide why are we doing this, or why is the public body doing this, and again the Supreme Court emphasising there in Mosley the importance of consultation, that it results in better decisions, avoids the sense of injustice, and is about the democratic principles that are at the heart of our society. And there's also a reference there which is very relevant in cuts cases, the case of LH and Shropshire, which is again a case of Owen Mitchell's and my own, which was about the closure of a day centre by Shropshire County Council, where it was emphasised two points actually. The first about higher demand when depriving somebody of an existing benefit. That wasn't from the LH and Shropshire case. What it means is if you're cutting a service, there's a higher demand on what fairness is, but also from the Shropshire case, a failure to consult before withdrawing the service will be unlawful. And that's why I say I think most public bodies will be consulting here before they make cuts. I certainly would hope so, and LH and Shropshire makes it clear if they don't that would be unlawful. As I said, the last of these slides I'm going to rattle through, and so we're now very close to the point of questions. This is just some real detail about legal aid funding. As it says, the headline points there, you have to qualify two different sections. The first is an income test, and the second is a capital or savings test. But what's really important there is that link on that slide, which is an eligibility calculator set up by the government. And what that does is if you click on it, it allows you, it kind of runs you through a series of questions which allows you to, which will conclude at the end, yes, you qualify for legal aid, no, you don't. And so you can put your own personal financial circumstances into that calculator, and it will tell you whether you qualify. The very headline point, however, is that if we're talking about a disabled child, or indeed an adult with a learning disability, for example, who's never worked, who has no savings, who's on benefits, they will almost certainly qualify for legal aid. Just then to rattle through these, the details, then I'm going to leave the slides up here and I'm not going to go into them in a great deal of detail. The slides, my email address is available at the end of these slides. They'll be available, and again, I think this is going out onto the internet afterwards, so you can see it all there. But there's some of the detail about the income test, and stressing that some benefits like income support, for example, are passport benefit. Are passported. It means if you're on one of those benefits, you automatically pass the income bit of the test. And there's a bit more detail there about what happens where you have dependents and how those are calculated. Again, I'm not going to go into that in any detail now. And then secondly, there's the capital test or the savings test. It does look at whether or not the individual owns their home and whether they have a mortgage. Again, the very simple point, the most simple point is the last bullet point. If an individual has savings of less than £3,000 and doesn't own a home, they will pass that capital test. And that's the end of my kind of piece as well. I think we're now going to go to the questions that we've had in whilst Steve and I have been whittering on.
Exactly, Alex. Thank you very much. I've been assiduously following the questions. They come in from Helen. Please do keep them coming. We're going to have time to answer more than we've had so far, but we've had a good number already. Alex, I'm going to sort of be question master because Super. I've got the screen in front of me, and there's quite a few that pick up some very important practical points that you've just raised. So we'll start with those. First question from Sarah Jones. And you did cover this, but I think it's so important, we'll re-emphasize it. If parents mount a legal challenge against the council with children as the claimants, and it goes all the way to judicial review, but they lose, will they be liable for the council's costs?
Yeah, great. So I agree, really important to stress it, and very simple answer, no, they won't. So legal aid, as I said, provides the protection to mean that you won't have to pay for your lawyer and you won't have to pay the other side's costs either. There's a tiny caveat to that, which is if a litigator behaves unreasonably, there can then be some exceptions to that. But of course, it's certainly our job as lawyers to make sure that there is no unreasonable behaviour. I can tell you in the many years, more than a decade, I'm sorry to say, of doing this job, I have never known a legal aid claimant to have to pay any money, and within Owen Mitchell, so not just me personally, but within Owen Mitchell and the Public Law and Human Rights Department that I'm a part of, we have never known any claimant to have to pay anything when they have legal aid protection.
That's really helpful. So it's extremely clear. Another important legal aid question, this time from Sam Carlisle. How quick is the legal aid process? I'm trying not to chuckle while I ask that to you.
Legal aid, the reason that Steve says that is because legal aid is something of administrative difficulty sometimes. That said, at Owen Mitchell, we have a very good relationship with the legal aid agency, and certainly if you go to a good law firm that are used to practicing with legal aid, they will be able to take all of the stress of that out from you. How quick is the process isn't an easy question to answer, because it does actually depend upon how urgent is the case. Yeah. And the legal aid agency will have various processes in place to make sure that urgent cases can be picked up. So within my department, we deal with a number of urgent medical treatment cases, for example, whereby you might be needing legal aid immediately. You may be seeing a judge at midnight about whether life supports can be removed, etc. You can have decisions made super quickly. Again, I keep referring to Nascot Law because it's the most recent case that we've run, although there's a number like it. In Nascot Law, and I'm pretty confident we had a decision on legal aid within 24 hours. But again, it's something which I can assure you, certainly from my own perspective, the stress of that will be taken out of your hands and dealt with by your lawyers.
Exactly. I emphasise what Alex said about making sure you've got good solicitors that are going to do all that for you. And another legal aid question, unsurprisingly, we've got lots of legal aid questions, this time from Paul Watson. What would you do when challenging cuts if the advice from particular solicitors is that legal aid would not be available to challenge the cut? I mean, let's assume for present purposes it's because they think the case hasn't got merit. Yeah. What can an individual parent or a campaign group do in that situation?
So that's quite difficult. So first of all, most lawyers will speak to individuals, speak to clients without any cost to take details about their inquiry and to establish whether they can assist. And certainly at Owen Mitchell, we would do that with every inquiry we receive. That doesn't mean that we're going to start advising, because we can't do that without having proper file in place, etc. But we would certainly be able to look at it and to consider the case and the kind of outline details. If you've already gone to a law firm and that law firm say there's no merit in this case, someone can't really kind of keep going around different lawyers until you find somebody who says what you want to hear. And the legal aid agency will rightly say, well, we're not just going to keep funding someone to get the same bit of advice from 3 or 4 different lawyers. That said, it wouldn't be that unusual for me to be contacted by somebody who says, I went to X law firm and they said there's no case in this, can you have a look at it? And we would probably do that on a pro bono basis and say, is there any merit in this still?
Yeah,
I hope that answered the question.
It does, thank you. I have a very specific, very interesting question for you, Alex, because it's about Nascot Lawn, and it's from Gillian Warwick Thompson, who asked why the Children and Families Act duties on promoting integration and joint commissioning didn't come into play in Nascot Lawn. And I think the answer to that question is that they did, but they may not be reflected in the judgment. So is there anything you want to say about that?
This is the joint commissioning between the local authority and the CCG.
Exactly, yeah.
So Nascot Lawn, as I think is probably often the case, what happened in Nascot Lawn was a two-day hearing, which is then condensed into a judgment, which is relatively short. And in fairness to the judge, he stressed in his judgment that in fact he was going to give his judgment even more briefly than he might have done otherwise, because he had already decided that we'd won on the first ground, which was that Nascot Lawn is a health service. Because it's a health service, that meant that, and it was a significant change, that meant that the local authority and the CCG had to go through a specific process, which involves consultation between the two of them and can end up with Jeremy Hunt, the Secretary of State. And so the judge in Nascot law was particularly keen to focus upon that process and less so on all of the other duties that we said were at play about the obligations on different public bodies, and in this case the local authority and the CCG, to cooperate with one another. So we did make a number of submissions within Nascot law about the obligations on the public bodies to have worked together, and indeed one of our key arguments was to say that the public bodies should have worked together to come to a view before consulting parents. But it's also fair to flag that the judge wasn't with us on all of those, or at least some of those arguments. But I think that that might be quite a long-winded answer, but I think the short point is the judge, having decided that we won on the first point about the failure for the public bodies to consult, probably then didn't go into a great deal of detail about the submissions we made about all of the other bits of law that say they must work together.
That's absolutely right in my view as well. Two interesting questions now on process and timing. We've just had a flood of further questions, so we're going to keep the answers a little bit shorter now. That wasn't a dig, Alex. Sarah Jones says, so if a council's voted on budget cuts and say they will be sharing their equality impact assessment a while after that decision, shouldn't they have done this before making the decision? We might be able to give a one-word answer to that question.
Go on, you can give a one-word
yes,
answer.
They should have done. And then the next question, of course, is, well, what do you do about it? And the answer to that is speak to someone like Alex, frankly, because that would seem to be a fairly nailed-on ground of challenge in general terms, of course, with the caveat on my first slide that we are not providing any advice here today. But in principle, the sorts of rearguard action, which is a quote from the case law that Sarah's describing there, raise interesting issues.
Yeah, I mean, I think the equality impact assessment you would normally expect to be as part of the pack that goes before the decision maker, before they make the decision, and all that information will be available online, and you can just get it from the council's website. If that scenario actually arose, that I think it was Sarah who asked the question, that there's a pack of information and the equality impact assessment is not available there, and in particular if that means it wasn't available for the decision makers, as Steve's alluded to, that seems to indicate very large alarm bells ringing that may well be unlawful.
Exactly. And Paul, we've answered one question from already, also asked another interesting question, which is, if now is the right time to consider taking action against cuts because the budgets have just been set, is it not better to campaign during September, October, when local authorities are deciding what cuts to consult on, to try and stop the cuts even before being proposed, and so not needing to resort to local action?
I can give a one-word answer to that as well, I think, which is yes, definitely. I mean, I think although the budget is being set now, cuts take place throughout the year. But it's absolutely right that engagement with the public body should be taking place around that timescale that was mentioned, but actually throughout the year, making sure that that local officers understand just how valued and important these services are. And of course, as Steve and I are here as lawyers, people come to us at the end of that process. Yeah. I don't see or don't see as often all of the steps that people have taken to make sure that the cut didn't happen in the first place. Exactly. People don't come to us saying, I've got this great service, the local authority are continuing to run it and I'm really pleased.
No, that's right, we only ever get the bad news.
Yeah.
But just to stress on that, it's something I mentioned earlier in the talk, that there are different points in which you can intervene legally, and really what I think you want to do is intervene at the highest possible point in the process. So if you can stop the budget being cut, then that's fantastic. If you haven't managed to stop the budget being cut, then you're going to end up in an argument about, well, where does the cut fall? And it might be that, say, children's services funding was cut. Well, you might be arguing that services for disabled children should nonetheless be protected. So it's less attractive and probably not what you want to be doing. But it doesn't mean that if you've missed the budget, it's game over. It just becomes more difficult to argue that the overall envelope should be increased or at least stay the same.
Yeah, I agree. And again, these are things which are quite complicated for us as lawyers. Yeah. And I would say as parents or advocates, you know, do go to a lawyer saying, I'm not sure when the decision was taken, I'm not sure how it is, but can you help me? And again, like I said, certainly we would do that without charge, and I'm confident that my fellow legal aid lawyers would do so too.
Yeah. And I would stress, and I've said this a number of times, anyone who's heard me talk before will have heard this, I'm sure, that I've never known a family with a disabled child take legal advice too early, because if they're too early, good solicitors will tell them you're too early. But I've known so many take it too late, and that applies in relation to cuts just as much as it does in relation to individual services. On which point, Lisa asked, we've talked about challenging cuts, but is there any history of people challenging local authorities and CCGs for non-delivery of services? And of course, the answer to that is absolutely yes, there is. And that's probably the majority of our caseload. It's about sorting out individual people's packages of support, or helping groups of people who receive the same service to keep it. What we're here today to talk about is really the big picture stuff, the challenges to the cuts. But it's actually much easier, really, to challenge non-delivery of individual services by way of judicial review, particularly if you've got a specific duty which says that those services have to be provided.
There's an interesting part of the Care Act about the requirement to have a marketplace of services, and I don't know if this is what the questioner was alluding to, but certainly if you have an individual assessment or care plan which says we're going to deliver this service, to then not do it is just out and out unlawful. And the scenario that I see most common is where a public body says we want to do it but we can't find anybody. We haven't got the quality or the carers are sufficiently trained or whatever. Again, to be blunt, that is a problem which lies entirely at that public body's door, and you as families shouldn't be prejudiced by it. And if that means they have to spend a lot more money, they have to pay a higher rate, whatever it might be, then they must do that.
Yeah, agreed. Another legal aid question from Andrea Elwood, Alex. How might legal aid be applied for in a case where there's an 18-year-old autistic young person who hasn't had a mental capacity assessment? What's the process in that kind of case?
So what I have to do as a lawyer is to assess whether the 18-year-old young person has capacity to instruct me. And capacity is often referred to as being kind of issue or decision specific. So we don't talk about somebody having capacity in general terms. It's, do you have capacity to make the particular decision? And so maybe somebody has capacity to make day-to-day decisions about what they want to eat or what clothes to wear or something like that, but lack the capacity to make a more complex decision about where they're going to live or whatever it may be. The specific question for me in that scenario about applying for legal aid is, does this person have the capacity to instruct me as a lawyer? There's a particular test there. If they have the capacity, then I would apply for legal aid on their behalf. And if they lack the capacity, then I would still apply for legal aid on their behalf, but with a litigation friend. And that's the point I made before, which means that probably a parent or someone would give me instructions on their behalf.
Right, we're going to move on even more quickly now because we're getting a flood of coming in from Helen, which is great. I'll take this one. Laura Jones asks, do local authorities have to consult on budget proposals, i.e. the decision to save money on short breaks by, for example, merging or shutting homes, even if the exact details decision has not been made? And the answer is almost certainly yes. There can be a statutory duty, a specific duty imposed by Parliament on public bodies to consult. In many areas there will be. But even if there isn't, then the common law, the law the judges have come up with to fill the gaps in between what Parliament has said, will often require consultation. Certainly if there's been a history of consultation, or if it would be unfair for there to be no consultation. And in Alex's LH and Shropshire case, the court said if you're taking a benefit away, like considering closing a day centre, you must consult. So the answer to Laura's question is, in practical terms, yes. It's very unlikely, I think, that the local authority would even try and argue that they didn't have to consult. The argument would be about whether they had consulted properly. Sam Carlisle asked a question about, which essentially, rather than going into the detail, Sam, I'm going to put Alex in more general terms, which is about the interplay between CCGs and local authorities. And it's where, in this example, CCGs are supposed to provide therapists and nurses for an SEN school, but they've stalled meeting the increasing level of need. What's the legal redress here? I mean, the answer is judicial review, isn't it? There's no other remedy here apart from judicial review, is there?
Yeah, and again, what we would do as lawyers there is write a letter before claim, which sets out what we say they're doing, which is unlawful. And most of the time, if it is plainly unlawful, that would resolve the matter. Again, we don't want to give the false impression here. The number of cases which actually go to court are very small.
Absolutely, because most of the time a good letter before claim by Alex or one of his colleagues will sort it out.
Yeah.
And that's why what you actually see in the judgments is the tip of the iceberg, really.
Yeah.
And when you're thinking about the success of judicial review, you have to take account of the vast number of cases that will be resolved successfully before it ever goes anywhere near a court.
Yeah.
And that's often ignored. So a couple of other questions that are very pertinent and that I know Alex will have a view on. Another from Laura Jones. What if the local authority have run down a service so it appears it has less need?
Yeah, that's a really good question, and it's something we see quite a lot. It's a difficult one, but it's one that we have to tackle by way of evidence. And so we have to show that actually this is a good service, that people haven't been placed there. And I've had scenarios like that in the past whereby we've got statements from family members who say, I would like my child to have gone there, but the local authority told me I wasn't allowed to, etc. I'm well aware of that scenario, but it's one that we tackle by way of evidence. I know we're trying to move on, but it actually might be quite a good question to also flag the fact that judicial review proceedings do not involve live evidence. So what you've seen in court where somebody's being cross-examined or you can't handle the truth, that's not going to happen. All the evidence is done by, is prepared by your lawyers by way of a written statement. And so if anyone is concerned about having to stand up in court and be cross-examined, that won't happen within these proceedings.
So we're now going to just go to the questions from people who haven't had a chance to have one answered yet, and then we'll come back if there's time to the further questions from those we've already answered towards. So we've got one from Arun Kumar here, which is an interesting question about saying that therapy services are going to be determined by local priorities and resources rather than necessarily in accordance with the child's education, health and care plan. And that's, I think I can answer by reference to what Tribunal Judge Jane McConnell would always say, which is that the law trumps local policy. And I think in the SEN field in particular, more perhaps than in health and social care even, there's this belief amongst local authorities, some local authorities, that the things that they do must be right because they're the things that they do. They're in their policies. And unfortunately, that isn't, of course, how it works. The rule of law says that local authorities have to follow the law, not their own policies. So you would need in those kinds of cases to take advice. See if we've got any other new questions. So I'll come back to one that Andrea has asked, Andrea Elwood. How about challenging increasingly narrow eligibility criteria to access disabled children's services that don't necessarily openly relate to budgets, but suspiciously diminish in line with budget cuts? What do we do about eligibility criteria, do you think, Alex?
Well, I mean, so eligibility criteria in relation to children is slightly different in relation to adults, first of all. So in relation to adults, just to kind of not answer the question for 2 seconds, there's very clear eligibility criteria set out in the Care Act, which does make the law in relation to adults, I think, Steve, you may think differently, I think much clearer,
yes,
much easier to say this policy is lawful or unlawful. Again, you may disagree with me, but as soon as I see that a local authority have an eligibility criteria in relation to children, that rings big alarm bells to me. But it's possible to be lawful. I don't know what you think.
Yeah, I mean, a couple of thoughts on that. First of all, children's social care law is a mess. The fact that the key duty for children's social care is close to 50 years old and comes from an act that was first passed in relation to disabled adults and only extended to children in 1989 and now left as a kind of residual provision for children when the Care Act has modernised the law for adults is a disgrace, in my view. We can use it still, but it's horribly out of date. And so Alex is right that challenges for children are more difficult in that regard. We also had very clear judicial guidance in the Islington case that said, where the judge said that there was a pressing need for statutory guidance on eligibility criteria for disabled children's services. And that was, I think, 2008, so 10 years ago, and we still haven't got any. So we don't, not only do we not have proper law on children's social care, we haven't even got proper guidance either. What we can say, though, is that the Chronically Sick and Disabled Persons Act requires services to be provided where it's necessary to meet the child's needs. And so there has to be a proper threshold adopted, which allows a local authority to work out when is it necessary, as opposed to merely desirable, to meet the child's needs. And any criteria that are as high as, for example, saying we only provide services where there are child protection concerns must be unlawful, because that's the Section 47 threshold under the Children Act. And the Chronically Sick and Disabled Persons Act is a welfare provision that must go beyond what the child protection duties say. You've also got things like the Section 11 duty, which I talked about in introduction, the public sector equality duty. There's loads of ways in which eligibility criteria can be challenged. And so again, the message is get advice as early as you can.
Yeah, that's what I was going to say. Again, if you're concerned about eligibility criteria, and in particular you've been told you can't have this service because it doesn't meet our eligibility criteria, those are things which I would definitely say go to a specialist lawyer to have a look at.
And the timing issue on that isn't quite as sensitive, is it, Alex? Because if you've got an ongoing policy that has effect every single day, the fact that it might have been adopted a long time ago is still relevant, and you'd like to challenge it immediately. That would be ideal. But the court may well say, well, okay, we accept that in effect this is a decision that doesn't really have a limitation point because it's being applied to new people all the time. Better in that case, I suppose, if the challenge was brought by someone to whom it had just been applied. But for example, in the Matheson case I did, which was about the rule taking away disability living allowance from children in hospital, those regulations have been enforced for decades, and the Supreme Court wasn't in the slightest bit worried about that. Perhaps the Supreme Court is particularly relaxed about those things, though. So one of the problems in this area is that different judges take very different views. So there's very few hard and fast rules. But the take-home point on this is that you can challenge policies and criteria later than 3 months if they are continually being applied to new people. Right, so let's have a few more questions coming in. So a question from Aaron again, Aaron Kumar. If a group of parents want to go for judicial review, can they get legal aid, Alex? How does legal aid work in relation to potential group challenges?
Yeah, so legal aid is brought on behalf of an individual and that individual's financial circumstances. But these cases are very often brought in reality on behalf of a group of people. So if we look at Nascot Lawn, or indeed look at the LH and Shropshire case that we've talked about, which is the closure of respite centre there, the cases were brought on behalf of a few individuals, but are plainly to achieve the outcome of preventing the service being closed for everybody. So Nascot Lawn was brought on behalf of 3 families, but it was very clear that we were acting on behalf of a much wider group. We actually filed witness statements from 3 other families, and my clients, who are a fantastically organised group of parents, in fact produced a dossier which I think had about 30 parents on it, and explained their circumstances, how it was going to impact on them. And I think that was really helpful for our case, to be able to show to the judge that this isn't just a couple of awkward people. This view is shared by everybody who's using this really valued service. But what we would do as lawyers is to say, right, let's find a few people who are willing to be the claimants, and then they can bring it on behalf of the wider group. But the legal aid agency won't allow us to have 20 claimants, for example, because of course that increases the cost a huge amount.
Interesting question from Paul. Again, if there's a difference between policy and the law, where does the role of the local authority monitoring officer come into it? And their duty is to ensure local authorities follow the law. Alex is helpfully pointing at me at this point. The monitoring officers are an interesting beast, and I've looked into this briefly on occasion. I think all I'll say at this stage is they are part of the toolkit of potential ways in which you can get things resolved, like the MP, like local councillors, the lead member for children's services or the lead member for adult services, like senior officers. There's certainly no harm in copying any correspondence you send to the monitoring officer. And of course, there's another complaint route here. In all of our areas, there are statutory complaints processes that can end up with the ombudsman, which we haven't talked about, which can be a very powerful remedy, particularly where things have gone wrong in the past and you're looking to get financial compensation or so on. But at the end of the day, none of those bodies will be likely to reinstate significant funding cuts. And none of those bodies can actually tell anyone what the law requires, which is a really important point, because sometimes the situation will simply be that there's a dispute between you and your local authority or CCG about what the law requires, as there most obviously was in Nascot Lawn. There was very little way it seems to me at least, that any kind of mediation or other process could have resolved an Ascot law, because there was just a fundamental disagreement about what the law required. And in those situations, it's hard to see what the remedy will be, apart from to go for judicial review, because then the judge can say what the law is.
I think I've only ever engaged with a monitoring officer when I've been trying to get disclosure of records and papers, and where the public body is saying we can't provide you with some information. I've gone to the monitoring officer who has particular responsibilities there, I think.
Exactly. It does have a broader remit, but rather than go into that now, I think we'll just say that it's something for people to consider and look into, and ask your local authority who it is and make sure things are copied to them. But that may not be an ultimate remedy, particularly in big cuts cases. So we've reached the end of our time. I've got one more excellent question, or perhaps a statement that Alex and I might like to comment on briefly to wrap up, and it's from Laura again. She says, it's not a question, but it seems to me that local authorities are flouting the law left, right and centre. Alex, what say you?
I say two things. One, as I said, as we stressed before, people come to us when things have gone wrong. And so I'm sure I have an overly negative view about how local authorities are working, because where things are working well, they never come to me. That said, I think it's right to say that we regularly are instructed on a daily basis, where people say, I was told this by my social worker, or the local authority said that, and are doing things which are clearly unlawful. And sometimes that's because mistakes are made. I'm not here to just kind of beat local authorities over the head. But what I do say is that families, disabled children, disabled adults shouldn't suffer because public bodies are not acting in accordance with the law. And I think it's right to say, and I think most local authorities would accept this, their finances are in such a difficult place that corners are being cut. And where corners are cut, it's more likely that unlawful actions are taking place.
I agree with all of that. I spend an inordinate amount of time on social media. Hello, everyone who I speak to on Twitter. And it is quite depressing at the moment, you know, the extent of the difficulties. And I would say on a daily basis, I see things coming across my Twitter feed that cause me grave concern about the legality of what's being done, shall we say. And I echo what Alex says, that of course there are many areas and many situations that are fine, and we're not hearing about those, but there's also a very widespread concern about the lawfulness of decisions, which in my view is only going to get worse as the cuts will continue for the foreseeable future. And there's a real power imbalance here, because it's quite understandable, I think, that many families start out on this journey by assuming that what their local authority are doing is lawful, because, you know, why on earth wouldn't you think that? And the level of public education around the law in this country is really low. People have a reasonable degree of respect for public bodies, generally speaking. And so you think, well, if they've said that, you know, it must be true. And then perhaps the scales fall from the eyes and people become a bit more clued up and are then rightly starting to challenge. And I think there's a really important role for those who've been on that journey and who've been able to spend time with us today to educate and inform and support others and spread the word that actually you do have rights. You know, at the beginning of the Disabled Children's Handbook, we've got 2 pages where we've tried to summarize all the key rights. And then there are the broader regard and sufficiency duties as well that need to be followed. Those are legal issues. They can be enforced. And there's still a legal aid system in this country which is moderately functional and which allows them to be enforced. And so don't just take it. And we're here to help.
Good. I think we've more than exhausted our allotted time. As it says on that last slide, there is a short questionnaire which will launch at the end of this webinar. Contact would be really grateful if you would spend a bit of time to complete that, so that they can help use that to help plan future events. And lastly, the webinar will be available on Contact's website. I think it's going to YouTube. And so I'm sure there'll be further communications going out about when that is available.
Yeah, and thanks to all of you for being here with us today. Thanks to those who listen later, and thanks to Helen and the team at Contact for making this all work so smoothly.